What is contributory negligence in Virginia, and how does it affect your personal injury claim? If you are even slightly at fault for an accident in Virginia, you may lose the right to recover damages. Contributory negligence in Virginia means you cannot recover damages if your own negligence helped cause the accident. This rule is a defense that can completely bar recovery in a negligence case. Under this strict standard, being 1% at fault can bar the entire claim. Virginia is one of only 5 jurisdictions that still applies pure contributory negligence. Most states use comparative negligence systems where compensation is reduced by a percentage of fault instead of being eliminated. Negligence is the legal foundation for many personal injury claims when someone fails to exercise reasonable care and causes harm. To prove negligence, you generally must show a duty of care, a breach of that duty, causation, and damages. Damages can include medical expenses, lost wages, and pain and suffering. Contributory negligence is an affirmative defense, which means the defendant must prove it. The defendant must prove you acted negligently and that your negligence was a proximate cause of your injury. Proximate cause means your actions directly contributed to the accident and resulting harm. Virginia juries cannot split blame between parties or assign percentages of fault. If your negligence proximately caused the harm, recovery can be barred even if the defendant was more negligent. Insurance companies often raise contributory negligence early and look for evidence of shared fault. They may scrutinize police reports, witness statements, accident photos, and your own statements for anything that can be framed as carelessness. Because the rule is all or nothing, small mistakes can become the central issue in the claim. Virginia law recognizes important exceptions that may still allow recovery despite contributory negligence. One key exception is the last clear chance doctrine. Last clear chance can allow recovery if you were initially negligent but the defendant had a later, clear opportunity to avoid the accident and failed to use ordinary care. Virginia's model jury instructions describe 2 versions of last clear chance, and each version has specific elements that must be proven. Another limited exception involves employees of certain common carriers under Virginia Code Section 8.0158. In those employee claims, contributory negligence does not necessarily bar recovery, and damages may be reduced based on the employee's share of fault. The statute also provides that an employee is not considered contributory negligent when the carrier's violation of a safety statute contributed to the injury or death. Contributory negligence also does not apply when the defendant's conduct rises to willful and wanton negligence. Willful and wanton conduct means reckless disregard for the safety of others. The source notes drunk driving typically qualifies as willful and wanton conduct. In that scenario, ordinary negligence by the injured person may not bar recovery. Virginia law also treats young children differently for contributory negligence purposes. Children under 7 are presumed incapable of contributory negligence. Children between 7 and 14 are judged by a modified standard that accounts for age, intelligence, and experience. Contributory negligence can affect many types of personal injury cases in Virginia, including car accidents and premises liability claims. Because defendants may argue your actions contributed to what happened, what you do after an accident can matter. The source recommends seeking medical care promptly and following through with treatment. The source recommends calling law enforcement and requesting a report. The source recommends documenting the scene and collecting witness contact information. The source recommends avoiding fault-based statements like apologizing or speculating about what you should have done. The source recommends speaking with a Virginia personal injury attorney early, especially before giving a recorded statement. A Virginia personal injury lawyer can work to gather evidence that shows the defendant's fault and challenges claims that you contributed to the accident. The right lawyer can also evaluate whether exceptions like last clear chance may apply based on the facts. At GibsonSingleton Virginia Injury Attorneys, Ken Gibson and John Singleton represent injured clients in Gloucester County, the Hampton Roads area, and across Virginia. The firm notes that insurers use contributory negligence to deny claims, and the response emphasizes building a record that counters those tactics. This law firm also offers a zero-fee guarantee, meaning they charge nothing unless they win the case. If you have questions about how contributory negligence may affect your situation, an attorney can explain how the rule and its exceptions apply to your facts. For help with a Virginia injury claim, contact GibsonSingleton Virginia Injury Attorneys at 804-413-6777 and visit 4073 George Washington Memorial Highway, Hayes, Virginia, 23072, United States.